Good morning, Chair, member of the working group, and fellow contributor. Thank you for the opportunity to speak before you today on the legal framework of land ownership and registrations in England and Wales. Before diving into our today's discussions, it is helpful to understand how the evolutions of the land registrations in England and Wales have been. It began with the normal conquest of 1066, which introduced feudalisms and centralized land ownership under the crown, forming the basis of modern land law. Key reform followed, especially the ROA 1925, which introduced the mirror principle and current principle and insurance principle, expanded overriding interest and laid down the groundwork for a central registered system. There are also several amendments made between 1925 and 2002, such as ROA 1933, LCA 1972, and ROA 1998. This reform refined the registrations process, clarified the land charges, reduced fraud risks, and streamlined transactions. The Land Registrations Act marked the most significant update, aiming to modernize the system through an electronic conveyancing, enhancing the transparency and reduce fraud and limit the overriding interest, particularly those kind of actual occupations and easement to be better protect the purchaser. Into our first discussion today, the mirror principle ensures the land registrations provide an accurate and conclusive reflections of the ownership and interests affecting the land. As noted by Judy Breed 2022 and Dixon Martin 2016, it allows the purchaser to rely on the register to discover all relevant interests, except limit overriding interest. By requiring the reasonable inspections of the land, it promotes clarity and certainty, which essentially upholding the idea of what you see is what you get, to protect the purchaser rights. In addition, the current principle is in the detail of interest that the trust should be kept off from the register. The interest will be overreached when the land is sold, so that purchaser do not need to know the details. Instead, the purchaser only need to concern with the legal title of the land reflected on the title register. This principle aims to simplify title investigations during conveyancings, thereby promotes a greater efficiency in the conveyancing by avoiding complicated off-registered interest. The insurance principle encapsulates the idea that upon the title is registered under the registry system, the interest is protected by the state. This meaning that the purchaser who suffer loss by a reason of the conclusive nature, the register will be monetarily compensated under this principle. According to Martin Dixon, this was observed as an ambitious motive underlying the RA 1925, which has now remained underpinned in RA 2002. The function of these three principles generally work together to achieve its aim under the RA 2002, as above articulated regarding the objective RA 2002. It was central to create a complete and comprehensive, accurate e-register of title, simplify and modernize e-conveyancing, and reduce the number of overriding interests. The mirror principle ensures that both buyer and seller share a consistent understanding of the property interest, excluding overriding interest, thus reducing the likelihood of inaccuracies. Then, the current principle furthered the goal of simplified conveyancing by limiting registration to legal interests, avoiding entanglement and complex, equitable, and finally, the insurance principle protect the purchaser against loss, thereby encouraging registrations and increasing trust in the system. Collectively, these principles support the idea effective implementations of the RA 2002 and pave the way for ongoing reform in the land registrations framework. Now, the second discussion of our topic today is to evaluate the effectiveness of the mirror principle in practice. It should be noted that the mirror principle has no applications under the unregistered land system, as unregistered land has no central registrations record showing all interests, and therefore, our discussion for today will focus mainly in the content of registered land regime. A mirror principle in practice can be upheld by a register under the legal ownership, mortgages, easement, and restrictions and notices. First, we have the legal ownership document. A legal ownership document is introduced to record the informations of the land and the landowner in the registry system. The document always includes the information of the legal owner and or the legal proprietor. Provided that there is no error or fraud, this confirms who legally owns the land, supporting the mirror principle. Second, we have the registered easement. A legally registered easement is to refer to an assortment of the rights in land. These rights generally includes the right of way, the right of water, and the right of power. If the land is registered, the easement will automatically appear on the surveillance land title as a burden and on the dominant land title as a benefit. This means that anyone inspecting the registered land can see the easement clearly and understood the right involved. This upholds the mirror principle by ensuring certainty and transparency without a hidden rights that keeps under the system updated. Third, we have a mortgage. A mortgage as a registered third-party interest gives the lender the rights to take or to sell the borrower property if the loan is unrepaid. The mortgage must be registered under the LRA 2002. So this allows the purchaser to check for the third-party interests like banks before the buying of a property. So this ensures that all informations are fully informed and protected. This upholds the mirror principle. Now we have the restrictions and notices. This further promotes the accuracy of completeness of the register. Under the Sections 40 of the Land Registrations Act 2002, the restrictions may be limited by the power of the registered proprietor to dispose a land unless specific conditions are met. The register will only allow such dispositions if they comply with the restrictions or ensuring that any limitations of the owner rights are disclosed. Section 34 further allows the entry of agreed and unilateral notices to protect the third-party interests, with the registrar approving entries only when requirements are met. These mechanisms reinforce the mirror principle by providing a clear and updated record of all kinds of enforceable interests. In overall, the mirror principle is partially upheld in the practice of land registered in 2002, as the registered property a clear and accurate reflections of the legal ownership and third party over a land of a property. Legal ownership is recorded with essential and proprietor details with registered easement, mortgages, restrictions, and notices are all entered into the register, offering transparency and certainty to purchasers. So now we will see how the mirror principle is not upheld in the practice. In practice, namely the overriding interest provide under Schedule 3 of the RA 2002, the overriding interests are interests which are overrides registered dispositions which are not protected by any entry of the registered but which still binds the land. According to Schedule 3, Para 1 of the RA 2002, a tenant under a short lease of no more than 7 years can claim a beneficial interest over a land or a property, as long as the lease is a legal lease or an equitable lease in satisfying the three elements. First is an inclusive possessions. Second is a determinate period of time. The fourth is a valuable considerations. And then the lease will bind the transferee automatically, in line with Section 29 of the RA 2002. Second overriding interest, we have actual occupations. Another major is that where persons who occupies the land and holds equitable interest may be protected, even if the interest is not recorded. This principle recognizes that the physical presence and contribution can override later registered interests, specifically in cases where the occupier was not properly informed or consented to subsequent dealing. The court have taken a protective approach, prioritizing the rights of such occupants, even their interests are not appearance from the register, thereby illustrating how the actual occupation can frustrate the goal of maintaining a complete and transparent land register. Third, we have overriding interest for an unregistered easement. A further limitations of an unregistered easement or an implied easement, which also qualify as overriding interest under the Schedule 3, Para 3. These easements can arise through necessary long usage or even a common intentions and do not need to be recorded to bind a future purchaser. While they serve practical purpose, their existence may not be an apparent from the register, leading to a legal uncertainty. The law requires that such easement may be based on a genuine necessity, but not only for a mere convenience purpose. Nonetheless, their ability to bind despite being invisible on the registered undermine the mirror principle, aiming of providing a clear and comprehensive pictures of the ownership and rights. Last, we have the overriding interest of the registered mistake or the registered fraud. Under Schedule 4 of the RA 2002, The mirror principle can be undermined by registration mistake, specifically under the paragraph 1 or even a fraud under paragraph 3. In Gibbs and Merce, this is one of the case happened before. As an example, a fraudster registered a land in a fictitious person's name and sold it to another innocent buyer. The buyer's title was void. As the fake owner was never legally existed, this highlights how the law of fraud can prevent the register from accuracy reflecting the own ownership. In conclusions, while the register captures many legal interests, overriding interests are a fraud reveal that a mirror principle is not fully upheld in the practice, weakening its reliability and even certainty. Now, in the last discussions for today's topics is the reform to the RA 2002. The RA 2002 has faced several criticisms by the legal academic. For example, Gi Liang in Understanding the Land Registrations Act 2002 is an article which highlighted and challenged in the shifting of electronic registrations, noting that its success relies on the substantial technology investment and training. She also warned that the current data protection may be inadequate to prevent cyber fraud, potentially undermine the act of goals and of a clear and reliable certainty. In my view, several targeted reform could significantly improve the effectiveness and reliability of the land registration systems. First is to strengthen the cybersecurity law and infrastructures to reduce the growing risk of identity theft, title fraud, data breaches in an increasing digital conveyancing environment. Second is to enforce compulsory registrations of all lands to eliminate reliance on outdated title deeds, reduce uncertainty in ownerships, and create a more complete and accessible register. My third suggestion is to narrowing the definitions of the actual occupations to exclude informal and ambiguous claims, thereby reducing the risk of overriding interests that are difficult to detect for the purchaser interest or detect. Fourth, to shorten the lease threshold for overriding interest. This is to apply to only leases of less than 1 year, improving the transparency and reducing the burden of purchaser to investigate short-term unregistered interest. This reform would help to reduce the post-purchase disputes and enhance transactional clarity, supporting the Land Registrations Act 2002 goals of certainty, simplicity, and a more reliable ownership record. In conclusions of the discussions today, we observe that the mirror principle is an act of the key as to registered land system under the RA 2002, although it is partially upheld through mechanisms like legal ownership, registered easement, mortgages, restrictions, and notices. Its effectiveness remained limited by overriding interest, unregistered easement, and fraud. Considering these factors, the registered accuracy and reliability still imposing in a gap to be curbed. So to address this issue, reforms such as enhance the transparency to reduce unregistered interest and to balance the efficiencies of the e-conveyancing with robust data protections to reduce the RA 2002 are essential upon resolving this issue, and the modern land registration system is functioning effectively.